Good afternoon, members of the Judiciary Committee. My name is Aaron Romano. I'm a resident of Bloomfield, Connecticut. I'm an attorney for 26 years. I've been practicing in criminal defense. I'm a member of the National Association of Criminal Defense Lawyers, a member of the Connecticut Criminal Defense Lawyers Association, but I'm here appearing in my individual capacity. I'm here to support, to urge your support, and also commend Senate Bill 444, and that I do have some problems with Senate Bill 5509, Section 2. But more importantly, I want to address the proposed changes to the law in Senate Bill 5505. 5505 deals with individuals who are charged in criminal court and raise a self-defense claim. There are two changes to the law that are proposed. One is with respect to bail. Currently, the way bail is set, the bail commissioner's office and the court considers the strength of the state's case. Now, this is very difficult for folks who are facing charges when they're raising a defense of self-defense because they're admitting to the conduct, and so it's a very strong case against them. However, that ability to raise self-defense in one of the conditions or one of the variables that's considered in bail is not currently considered. What this bill does is it allows the bail commissioner's office and the courts to consider self-defense in setting bail, in evaluating the strength of the state's case. In addition to that, it also allows for a motion to dismiss to be filed in cases where people are alleging self-defense. And what this does is it is a mechanism to relieve the backlog of cases on the trial list and enable attorneys to apply for this dismissal of their case prior to a trial. Currently, the way it works is unless a prosecutor agrees to unilaterally withdraw prosecution, an individual charged with a crime must go to a full trial with a jury. This has an obvious impact when the jury lists currently are 2 years long. It has an obvious impact on the individual's life, affecting their ability to attain employment and educational opportunities. They basically must wait their time. This bill will empower a court to make the decision to dismiss a case involving self-defense. Currently, people who act in self-defense, they commit a crime, and they have to go through the process of an arrest, a prosecution, and a trial, even though their actions are claiming that they've acted in a lawful manner, that they're justified. And this would help alleviate the backlog within the court system, and then also it would help to reduce the impact that it has on these good citizens who act in self-defense.
Thank you, sir. Questions from the committee? Representative Khan?
Thank you. I have two questions. So I'll start with Section 1, since you just ended on Section 1. So I know you spoke specifically about how this would reduce backlog. I know I had heard some concern that folks had that it would do somewhat of the opposite, where it would create an additional, it would create a lot of unnecessary cases and place a burden on the judicial system. So can you speak to the way that you believe that it would reduce the backlog?
Well, in two ways. Right now, there are motions to dismiss that are filed in the civil context. So in civil court, when a case is on a trial list, motions to dismiss for various reasons can be filed. We don't see that actually creating a burden on the civil docket. Instead, what it's doing is it is eliminating a lot of cases from the civil docket. So from a civil context, we see that the motions to dismiss, they actually have a beneficial effect on clearing the docket. Secondly, from a criminal context, in order for someone to ask a judge to dismiss a case, the typical strategy of a defense attorney is to hold their cards close to their chest and not reveal their defense strategy. A motion to dismiss would basically be a preview of their case to the state. So I can only envision contexts or cases where the self-defense claim is so strong that a defense attorney would advise their client that this would be a good idea to move forward. In those cases where the self-defense claim was not strong, it would go to a trial. So I really don't see that creating a backlog. It would be a strategic decision, and only in those cases, from an attorney, defense attorney standpoint, I certainly would not want to reveal my hand to the state, knowing that very well the judge could deny my motion to dismiss, and my client would have been exposed to cross-examination. My entire case would be revealed to the state, and then they would have a dry run basically at the trial to win the trial. So I don't see a context where, unless the case is extremely strong, where an attorney would advise his client to move forward with a motion to dismiss.
Okay, thank you. And then my second question, on 5509, you mentioned some concerns you had in Section 2. Can you just elaborate?
Yes, this section was covered by another citizen who testified. On Section 2, Sub A, Sub 1, there's a proposed amendment for the odor of cannabis or burnt cannabis to actually amend that so there could be a reasonable suspicion to support a stop and search of a person who is under the age of 18 in a motor vehicle. And I think the context here is now once we have legalization in the state, there are people adults who might imbibe of cannabis inside a car. They might not be permitted to do that in the home that they live in, and it might be too cold outside, so the car might provide them that refuge. They're not certainly driving the car, but they're using it as a shelter. The next day, if a minor child then drives the car and gets stopped by the police, obviously that would give rise potentially to a search, an unnecessary search of the car, whereas this child is innocent from any potential wrongdoing. So it may have an effect that there will be increased searches of cars, especially with minors. And I think what we're trying to do now is we're trying to create an environment where there's more of a cohesive interaction between police and young people here. And if we give the police an opportunity to then be searching minors' cars, it's not going to really encourage that feeling of cohesiveness within the police and minor kids who will eventually be adults. We want there to be positive interactions with law enforcement.
Okay, I'm all set. Thank you, Mr. Chair.
Thank you. Further questions or comments, Representative Quinn?
Thank you, Mr. Chair, and thanks for being with us, Attorney Romano. I had some concerns in 5505 in Section 1 that oftentimes in a breach of peace situation or an assault third, you do have defendants representing themselves, and I'm wondering if we aren't opening the door for more people to claim the affirmative defense of self-defense to get themselves a hearing within 45 days and then potentially overburden the court system with these.
So thank you for the question. So I guess your concern is that a self-represented party would make an unnecessary demand or they would start making demands in a domestic violence situation?
Well, no, any situation. You know, I mean, oftentimes it's a fight between two people. And
sure,
nobody gets particularly hurt, so you aren't into the upper assault charges. But in the lower charges, I mean, are we going to have a system, are we going to create an avenue where anybody who thinks that they were acting in self-defense is now going to, you know, file the motion to have a hearing within 45 days and thus create a possibility of an overburdened GA as a result of this?
Yeah, Representative Quinn, I cannot conceive of a scenario where self-represented parties would do that because they would be exposed to cross-examination by the prosecution. And I think if there is a self-defense claim that's being raised, it may very well be legitimate, and perhaps it would force the prosecution to reevaluate their case and the docket could clear. In the cases that I've represented people with self-defense matters, I had one homicide several years ago that took close to a year to resolve. And during that year, that person was under house arrest with a GPS monitor, basically because they admitted to committing the homicide. Once the investigation was complete, from the state's attorney's perspective, they withdrew the charges. But for that entire year, this person was basically under house arrest. What this would do is this would force the case to move forward in a more efficient manner. So people who have acted lawfully, and I want to just qualify this, self-defense is where someone commits a crime, usually an assault, or it could be a homicide, but there is a justification for committing that assault or that homicide. So they've committed the crime, but they have a justification, a lawful justification for doing it. So the court process works through, and they eventually get to a jury trial. But this would circumvent the need to go that far with the 2-year waiting period, with people's lives being hampered by doing the right thing in a particular situation. So if I see someone in need, and I see someone in distress, a victim of crime, I intervene on their behalf. I'm now potentially facing an arrest, a prosecution, and I could be waiting for a period of 2 years for that case to resolve. And so this will help people understand that if they act, if they intervene, and they're doing the right thing, and they're a good Samaritan, they have an avenue to have the case dismissed rather than to go through that entire process.
Okay, and I understand exactly where you're coming from and the circumstances that have led to this, and certainly agree that in that circumstance something should happen much quicker. But I just have a concern that self-represented parties aren't necessarily going to be thinking like attorneys and realizing that by going for this they may be hurting themselves down the line. So that's just my concern on it. But again, I understand where you're coming from.
Thank you, Representative.
If I may just make one comment on
Real
that,
quick,
Representative
sir.
Quinn. Yes, the self-represented parties, many times in the court system right now, are a burden because they do not understand the court rules. And so unfortunately, the judges, prosecutors have to be very patient with that process. I don't think there are many self-represented parties who want to bring cases to trial or have hearings. They're looking to resolve their matter. So I don't have statistics to support this, but just my own experience in observing court. And I know self-represented parties in many cases, as you said, they're not making a wise decision by going to court alone. There usually are some other issues that accompany, unfortunately, those circumstances.
Thank you, sir. Further questions or comments? Seeing none, appreciate you being with us and any work.
Thank you so much for your time.